I am Jason with the Self-Represented Litigant Society, and this is how to win in family court. A workshop that is very simple. In total, there are what I'd summarize to be 4 points to what makes a successful person. A new topic once a month, right here on this YouTube channel. And then experience. Something that I recommend, just waiting for the YouTube videos to be uploaded, because there's a chance that they may not be uploaded. The internet signal here is not the greatest, and we need a strong, fast Wi-Fi signal to broadcast to the YouTube channel. So I emphasize that the in-person is probably a better experience than the YouTube version. Although, you know, if it were me, I would be biting at the bit, chomping at the bit is the expression, I guess. I would be chomping at the bit every time there was a workshop like this. I would be the first in line. And today we had 3 people registered for this workshop. And one person earlier today emailed and said that they weren't going to make it. The other 2, I want to stress, what that means to me is a sign that somebody is not going to be successful. You're going to do agreement. That may go to the... So, how to win in family court? Well, first and foremost, I have to stress that I don't think that there are winners and losers in family court. Well, I should rephrase that. I think that there are winners in family court. I think there are winners in family court. And those people typically are the court staff, the judges, and lawyers. Do you know why that is? Well, I think it's because they keep you in the system. If they're getting paid $300,000 like a judge is a year, if they're getting a $50,000 check at the end of each month, or a $30,000 check at the end of each month, because you're involved with family court, I'd say that that's a pretty good reason as to why they're winning and you're not. Because ultimately, what it boils down to is that a judge is going to make a decision about your family court case. And if you are absolutely serious about the application that you have or that you're involved with in family court, so if you're the applicant or the respondent, if you're one of those 2 parties in family court, you are the loser, no matter what. Because a judge is going to tell you what's going on. So where do you get that power back? Well, I will go into that in a little bit. But I have to emphasize again, if you are in family court, you're not going to win. I'm not going to just, say that this is the answer to this video, because it's not. But if you are in family court, you are in a losing position already. You're allowing somebody else to dictate. Somebody else. Think about that. Somebody else is going to dictate what happens to you and your, if you want to win in family court. That's the only way to win in family court, is to not go there. And I know that doesn't make much sense, because it seems like a big losing cycle there. But essentially, if you're in family court, somebody else is going to make the decision for you. You will get backhanded, metaphorically and even verbally. And or you'll win no points, or worse, the judge may order against you because your position is unreasonable. If you're in family court just to get some kind of vengeance on your ex-partner, or if you dislike them and you're taking a position just on the opposite of them. And what I'm going to primarily talk about today is that this is involving primarily kids. If you can't agree about a simple divorce, that's a huge issue right there. If there's financial details that are in question and are an issue, that changes the dynamic a little bit. But ultimately, what I'm going to be talking about today really revolves around if children are involved in some degree. Family court is family court. I'm not talking about divorce court. Although I can be. You know, these principles are very basic. There are, very limited circumstances where a matter will go to trial. Trial being the end result, the end point in a matter being started. So, if you're involved in a family court matter and you go to trial, very little cases go to trial. Less than 10% is what they say. And believe me, you don't want to be in this club. This is not a great club to be in. You don't want to be on a first name basis with all the clerks at the court office. You don't. You want to respectfully get in, get out, and that's it. And have them not know your name. That's ideal. But unfortunately, that doesn't happen. And if you want to win in family court, listen up. What's looked at more favorably by the court this is point number 2. If you want to be looked at more favorably by the court, you're going to want to invest in alternative resolution dispute measures. Alternative dispute resolution is sometimes what it's called, or ADR. But there is where you want to invest your time and energy if you're a self-represented litigant. Especially if you're a self-represented litigant. If you think it's all fun and dandy and what you see on TV, like Judge Judy, and the judge will guide you through the process. The judge may guide you through some procedure and some basic legal principles. But it's a big misnomer that the judge will hold your hand throughout the whole process if you're self-represented. If you're self-represented, the odds are against you. Trust me. Even though you may have a higher opinion of yourself and your skill level, the odds are against you. I have read the studies. I have read the opinions of judges when it comes to self-represented litigants and the achievement that they get in family court or other courts, and the achievement that they get, you spend learning the law or researching, you have the odds against you. You have them against you, and what can you do? Well, one thing you can and should do is invest more time, as I said, into alternative dispute resolution methods. That could be mediation, settlement, or other means of ADR. And that's more respected in the industry as a whole, especially amongst the judges. If you can be an amicable person with your ex-partner, it's more respected in the courtroom if you do go to the courtroom. Because, yes, you may go to the courtroom if the resolution discussions break down. This is also confirmed with self-represented litigants. Justice Brownstone says at chapter 4 in this book, when you start a case, you are starting a war. When you choose one of the following methods of resolving your case, known as alternative dispute resolution, you are making peace. Coming from a working judge in the Canadian family law system, these are words that should be your guiding principle as to how to govern yourself in family court, if you're in family court. If you're not going to have a lawyer, it will be in your very best interest to put some serious effort into ADR, or alternative dispute resolutions. So there are three primary methods of ADR, which are mediation. I don't think I need to explain these except for maybe collaborative law. Collaborative law, mediation, collaborative law, and arbitration. So mediation and collaborative law typically involve representation, typically involve lawyers being involved, and with mediation, there's a third party that is removed, and they will help the sides, negotiate settlement. That's the goal, negotiate settlement. In collaborative law, there's no mediator, but there's two sides that are represented, two or more sides that are represented. So, each parent or each party has representation by a lawyer. And then arbitration. Arbitration, you don't need a lawyer. Both parties can go to arbitration and hire an arbitrator, and the arbitrator will make a binding decision on you. It won't be a court order, so you will be able to go and get a court order if you go into arbitration. But when you agree to go into arbitration, you essentially submit power, and you're allowing an arbitrator at a lower cost. That's the benefit. That's one of the primary benefits of going to arbitration instead of being in a family courtroom, compared to a family courtroom. So, what you see on TV is not what you're going to be getting in a family courtroom in Canada. what you see on TV and the Judge Judys and the Judge Browns and whatnot, you're going to see that type of dynamic more so in a small claims courtroom. That's something where you will be able to, act unreasonably to some degree. These rules of the court won't strictly apply in a small claims courtroom. But you're not in small claims. If you're watching this video, you're in family court. In family court, there's a lot on the line. And if you model your representation over what you see on TV, you'll probably get scolded. You'll probably get scolded, and you will probably not be as successful as if you probably won't be as successful as you could be if you are putting these principles into action. So if you're going to continue anyway into secular even, possibly even impossible, you're going to have to disconnect emotionally from your case. Now think about that for a moment. How can I, as a father or a mother, disconnect emotionally from this case? This is one of the primary reasons why a lawyer is a good thing in family court. But unfortunately, because of the legal system and the legal costs and the lawyers being valuable people in society, they have such a higher value of themselves. Charging $150 to $250 an hour is not uncommon in Canada for a lawyer. And that's outside of court. If they're going into court, that's a whole new ballgame most of the time. So, I have an uncle. He's a criminal attorney in this city. A great uncle of mine practices criminal law, and his rate is something like $800 an hour if he goes to court on your behalf. Now, is that something that comes easily to you? No. And that's the primary reason why we see people representing themselves, especially in family court, because of money. And they can't qualify for legal aid because they don't live below poverty. They don't live below the poverty line. So, yes, it is more easily said than done disconnecting or removing your emotions from your case. But even though this may be the hardest thing you'll have to do, on to your emotional baggage that brought you into family court in the first place. So, how do you disconnect? The primary thing that people have a problem with, in my mind, and what I've experienced, at these, and that is probably the best thing that you can do for yourself if you're in family court. And I don't mean like getting walked all over. Submitting to the process and submitting to the system, it may have mercy on you. When you're before a judge, you have to understand that you have no control anymore. As I already said, you only have control over your behavior in the courtroom and how you represent your case. If you're going to sit outside the courtroom and have the other side's lawyer walk by or even your ex-partner walk by, that your ex-partner can give you, that will, set you off. That's control. They're controlling you. They're controlling your behavior and your emotions. And that will work to your disadvantage in court. That little smirk that they give you when you're in courtroom with them. That little I'm better than you kind of smirk. You want to be giving that smirk, not receiving it. And if you are receiving it, a stone cold stare back is probably in effect. Or, Dr. Joy Brown in New York City, she would recommend smile and nod, or play stupid and smile. The control that you're giving up when you get just even a look like that is very powerful stuff if you can't control yourself, if you can't control your emotions, and if that gets you going. That is something to consider when representing yourself. If that gets you going, just a look or just the sight of your ex-partner, that is a good reason to not represent yourself. A great reason. But if you're still going to represent yourself, here are some things that worked for me and for other people that have represented themselves in family court as being tools to add to your ability to deal with this. And it's stress, basically. For me, yoga and meditation. Yoga and meditation, well, you may be saying, oh my, that's for hippies or whatever. You can say that all you want and knock it. But if you're somebody who doesn't know how to relax and who doesn't know how to get to a place of zen or peace, yoga and meditation can help. It helped me. It helps so many self-represented litigants I talk to that I've recommended it to. It can increase your success odds just doing one of those two things drastically. Absolutely drastically. Another thing that I like to do that helps with this kind of stress and the stress of going into court is gardening. I love gardening. I love the environment. I love being in nature, just going for walks. That can be such a tool in your back pocket that nobody can take away. And yes, it will benefit you in family court. I promise. Or you'll get your money back on this video. I promise. Ha ha! You're not paying for this video. But if you were, you'd get your money back if I broke my guarantee. But it's a guarantee that if you put serious effort into taking care of yourself, emotionally speaking, going to get therapy, yoga, meditation, gardening, help you in family court. It will help you be successful in family court. Even though it sounds ridiculous, it will. So, and I want to stress, doing this by yourself or with other people that you don't know. For instance, in a yoga class where you don't really know anybody. I stress doing that because it's good to be making connections in the community. Because one of the primary symptoms that I've recognized and that studies all alike in this industry will tell you are that self-represented litigants feel isolated and lonely and alienate themselves in family court or when they represent themselves. So they talk about their case too much to their families. They talk about their case too much to their friends. And then what happens? Their friends and families just become yes people. They're like, yeah, you're right, buddy. And they're just trying to be supportive and nice. And is that truly supportive? I don't think so. I recommend getting away from them when you're doing these stress-relieving activities in your life, these general hobbies, because it's good to be staying healthy and active and being in the community, building your support network. Building your support network will help you in family court. It will make you a healthier person, I believe. It will make you, if you rely too much on your family and friends, what will that do also? That will hurt you and your family and your friends. And I don't think that's what you want to do. Trust me from experience that when I say this, that having a great family that is supportive is an awesome thing. It can't be beat. But relying on them as least as possible is probably the healthiest thing that you can do if you're in family court. Because at some point, it could cause irreversible harm. And you don't want that. You don't want the stress from your family court matter spilling onto your relationships in your personal life. It's not a great thing. I've experienced it firsthand. So yes, when your family are making comments like, oh, when am I going to get to see my grandbabies? Or, when you were together with X's name here, I knew they were bad news. Or even worse, you're right, and you should keep fighting that vile expletive until they are ground into the cement. If you're hearing that from your family or your friends, you're in trouble. You need to get and put some space between you and them with regards to your case. And you need to tell them to let go a little bit. Because if you don't, that will start to bring you down in court. And that baggage, that emotional, again, you can't beat a supportive family and friends network that you have. You can't beat that. It's great to have. But alleviating that stress is really important, I think. What you have to do if you want to win is you have to prove your case. Justice Brownstone, I'm going to put a video link below. Justice Brownstone did an interview with a certified family law specialist here in Ontario, a lawyer by the name of John Schumann. I'm going to put this video link below so you can take a look at this little segment, this video segment. If you don't know already, Justice Brownstone, the author of this book, Tug of War, CH here in Ontario, and I know that they put it online. They put it on YouTube. So I'll put a YouTube clip in the description box below on this video, so you can take a look at what they have to say about evidence. But evidence is something you have to prove. You shouldn't be going into court thinking that you'll be able to just rely on what you say, because that's not strong enough for most judges. 1,000% better if you go into court and you have unbiased outside thoughts and information that you can bring into court that will support your story. Even if it doesn't support your story, if you have the honesty to tell the full truth and nothing but the truth through other people, that will help you in court. Although, a good strategy will revolve around supporting your case instead of taking away from it. And you support your case with good evidence. And it will make a huge difference in court when you know what evidence is good evidence to have in family court. They talk about it a little bit in the video that I'm going to post below. So check out that video. So, what you want to avoid at all costs is hearsay. And hearsay is bad evidence. You don't want to be bringing hearsay into courtroom. And if you don't know what hearsay is, it's an out-of-court statement by somebody who isn't in court. Essentially, you don't want to be relying on hearsay. And it's just bad form. And you can object, and you can, get that hearsay taken out of the record. But it's better if you attack it before it gets into the record. And knowing how to object to some evidence is also a great thing. So, hearsay could be somebody's opinion or thoughts out of court. Say, for instance, brought into your affidavit. Now, what people don't think about that is also hearsay is police statements for the most part, or police reports, I should say. If a police officer makes a report, that's hearsay. That's not credible most of the time or reported to them. Now, even though that's hearsay, that's typically allowed and permissible, or admissible, I should say. But police reports in general, if you're trying to just add a police report to your case and think that you're going to get away with it, most likely the lawyer on the other side is going to object and get that shot down. And frequently, self-represented people are shocked to find out that the most crucial information they were planning on relying on in their court case was ruled inadmissible or not usable because it violated the hearsay rule. That was from Justice Brownstone's book, Tug of War. Again, you should read that book before going into court, especially into family court. Now, just like all civil courtrooms, a family court is a civil courtroom. Just like all civil courtrooms, the standard of evidence or the burden of proof is called a balance of probabilities. Is it more probable than not that something occurred, or that evidence is credible, or that this should be believed over that? That is the burden of proof that your evidence is going to be tested upon. So when you present your evidence, it's going to go through a test. The other side's story, or the other side's version. And whatever side tips that scale just enough in their favor is where the successful party is going to lie. You know what a standard of proof is in criminal court. The criminal court standard of proof or burden of proof is beyond a reasonable doubt. Now this is probably more than an 80% likelihood that a crime was committed. That's what's called a burden of proof. And that burden of proof is not used in a civil courtroom. It's not used in family court. So you have to know this. The standard of proof that's being used in family court is a balance of probabilities. And you'll hear that a lot if you make it to trial. You won't hear it so much if you're going to family motions. So looking for temporary relief before the trial is set to begin. So the trier of fact or the judge must have a firm belief or conviction in a piece of evidence's factuality. So what makes good evidence? Well, I've seen from my personal experience, I've seen judges admit and use evidence that is merely conjecture, which should be outrageous to you. It should be. But it happens. And do you know why it happens more in family court than anywhere else? It happens more so in family court because the court or the judge wants to err on the side of caution. That's what they say. They say all the time, I'm going to err on the side of caution. Because if this is true, this conjecture, if it's true, even though it may not be, if it's true, what could the impact be on a child that may not have a voice in that courtroom? Well, what makes good evidence is not conjecture. I'll tell you that. But if you're facing it, and it's some serious allegations that are happening, you better beware. Erring on the side of caution, you don't want to hear that phrase if you're on the opposite side of that. What makes good evidence is being open to all pieces of evidence. What makes good evidence is and could be a record, a bank record. What makes bad evidence in family court? A letter from anybody. Why? Because that's hearsay. It's hearsay until that person is brought into court and summoned. So that's what you do. You bring them into court and you summons them. You summons them and they'll have no choice but to appear and speak to the letter that they wrote. So if you have a letter, great. Hold on to that letter from the doctor or from your neighbor or whatever, the teacher. Hold on to it, but don't use that as evidence because that doesn't make good evidence. What makes good evidence is now that person being dragged into court by a summons, and it's very easy to summon somebody in family court. Well, into the family court trial, I should say. It's not so easy to summon somebody in on a motion before trial. But if you're going to trial and if trial is inevitable, it's easy to get that person into court. They could be arrested if they don't appear in court. There's a good likelihood that they would be arrested if they don't appear, if they've been properly served with a summons. So, do you think, ask yourself this question, do you think a parent that has recently separated from their estranged spouse and may have kids involved with that spouse, do you think that person is likely to be as objective as possible? Think about that. That's what you really need to look at when examining your personal belief system and your tools in your emotional toolbox. Can I be objective about this? Can I be objective about this piece of evidence and this piece of evidence? Can I be objective about it? That's really what you have to ask yourself. That's, again, another great reason to be having a lawyer represent your interests in your family law case. But being open to the evidence and what it says about your case. For instance, if there's a police report, if there's police involvement at all in a family law case, if the claim is domestic abuse or domestic violence, it's a good indicator that there's been a stressful environment. And now one party or the other may be wanting to use this police report or the idea of police involvement, just the thought or the expression of police involvement to the court. They may try and convey that or slant it in a certain way to overemphasize a perspective. But is that being truthful? Is that being as objective as possible? Again, what really is good evidence? And what is a police report? Let's go back to that. What is a police report? A police report is essentially hearsay. Not until the police officer that made the report gets into court and speaks to that police report is that good evidence. A general side note for when you're in court, especially in family court. I hear it all the time and it drives me nuts. Is never tell the court that this is the truth. Never tell the court that this is the fact. Especially if you're in an argument, in arguments or giving submissions to the court, like your opening statement. Don't say that these are the facts. The facts will be determined by the judge. The judge is going to determine the facts and how the law should apply to your case. So, think about that and what that means. What that means is that you should be submitting everything when you're giving arguments to the court, or when you're making submissions to the court, or making your opening statement to the court, as far as your court appearance is concerned. If you're in a motion, you're making submissions. You're not giving evidence. You're not saying that this is the truth. The judge will decide if it's the truth or not. As the self-represented litigant, your job is to say, this is essentially what I submit is the truth. I submit this for your consideration as being the truthful side here, Your Honor. I submit that this is the truth. It's what you propose happened. And I see it all the time, and this also drives me nuts, is when lawyers will give evidence when they speak, when they are giving representations or making arguments or submissions. They give evidence that isn't in writing before the court already. So if a lawyer is making an argument, and the argument is, for instance, that there was domestic abuse, But there's no police report in the record. There's no police report in writing before the court because you're not allowed to use the police report until the officer testifies. And the officer hasn't testified. If that's the case, and this is just an example, and that's the case, a lawyer sometimes will say, the police were involved, and this happened on this date, there was an abuse, and my client, they were abused. But the client hasn't given evidence to this yet. The client hasn't gone on the stand. The police officer hasn't been called on the stand. And if that is the case, if the evidence isn't before the court already, that is improper and illegal. The rules of professional conduct here in Ontario govern a lawyer's conduct, and a lawyer is not allowed to give evidence. They're not allowed to give their own evidence through submissions. And when a lawyer is giving evidence, that essentially means that there's evidence that is not before the court, it's unsworn, and that the lawyer is just speaking basically out there behind. And it's something where more often than not that can be easily shut down. But most self-represented litigants don't know how to shut it down. That's where coaching can come in. The coaching that we give to self-represented litigants all the time revolves around teaching you how to notice these kinds of objections to make, even if you're at a family motion. Most lawyers will know how to object to this, but will you, as the self-represented litigant, will you notice if a lawyer is giving evidence? Will you know what to do if it happens? Probably not. But that's what you need to learn how to do, is to object properly when bad evidence is being given, or if evidence is being spoken to that isn't before the court. Most people tell me often, well, I can prove this. I can prove that. I can prove this. Oh, really? I usually don't believe that person as soon as they say that. And usually it will revolve, when somebody tells me that, it will revolve around them saying, well, that's just, it will revolve around my testimony. I'll say that it happened. And really, does that make good evidence? No, it doesn't, as I've already discussed. What is great in family court is making a parenting plan that doesn't slam the other side, that doesn't slam your ex-partner, because your judgment may be clouded. If kids are involved, a parenting plan is necessary. And one of the elements of the parenting plan is how the other parent is going to be involved, essentially. So that's something good to think about when giving your evidence, is how will you prove your parenting plan? Will you call your parents as support people to testify, to answer to whether or not they will support you with learning how to be a better parent, or babysitting the kids if you need that? What's your parenting plan going to be? How are you going to prove that to the court? Well, with good evidence. And you can't just use your own words to do that. I briefly touched on it earlier, but a common misconception is that the judge essentially will pick up the slack for a self-represented person. Justice Brownstone addresses this in his book, and His Honor says that, the judge is not going to protect one party's interests over the other. Although, I have been witness to And you may have been witness to one person's interest, one party's interest being protected over another, in the interest of fairness, in the interest of a number of other things, fair hearing occurring, and other fundamental principles. But the judge is in charge of controlling the courtroom. They are in charge of process. They will explain procedure to you, and I see it often that, judges take, sometimes if there's a self-represented person, judges take inordinate amounts of time to explain procedure, and it just slows down the process. Every 5 minutes having to explain a new bit of procedure to the self-represented litigant because they think that the self-represented litigant needs that. And do they really need that? Well, no. They shouldn't need that because they should have researched. They should have done their homework before they got to court. But judges play two primary roles in family law. One is to make sure that the court hearings are fair and just. And two, to make the most just or best possible decisions for the well-being of families, especially children. As I said, sometimes judges will spend these inordinate amounts of time explaining procedure and law or principles. They won't tell you how that applies to your case. They won't give you legal advice. They cannot give you legal advice. If you're hearing legal advice from a judge, you should be making a complaint right now to the Canadian Judicial Council. Or the provincial judicial council in your province. But if you hear a judge, giving advice to you or the other side, that judge is now acting in a biased fashion, in my opinion. And that is what creates improper or imbalanced hearings. Will it help your case if the judge doesn't have to explain procedure to you? Of course it will. It will speed up the trial. It will get lower costs on the other side. It will bring down the legal costs for the opposing lawyer, or general costs in general. It will bring down the amount of court intervention. It's a win-win-win situation if you already know procedure going into court. If you already know what is to be expected, so the judge doesn't have to explain that every 5 minutes of something new. I suggest it will help a great deal and reduce the total length of time that you're going to be in court. And it will bring down frustration on everybody's part. So research is going to be the next item that is essential to winning in family court. Research. And what should you be researching? Well, the rules, court practice directions, the legislation that's applicable, common law, and case law. Those are 5 primary areas of what you should be researching before stepping 1 foot into the courtroom. Now, what I recommend to all self-represented litigants before they even start, before they even file their application, or before their first court appearance, is go start watching family court motions. Go start watching trials. Go start watching lawyers in action. Look at how the judges react to them. Examine the words that they use. Think about how their thought process is different than yours, and it is different than yours. Critical thinking is one of the things that lawyers study a lot of when they are in law school. Critical linear thinking is a tool that lawyers everywhere will have. Those tools that you should be now possessing. Being able to remove yourself emotionally, being able to critically think, being able to watch out for bad evidence and know what good evidence is. These are all things that will help you be successful in family court. You should be more familiar with the rules and common courtroom etiquette than the other side is. You should. There's signs outside the courtrooms all the time. You know, this is what the courtroom etiquette is. You should have that memorized. You should know that it's improper to wear jeans before a judge if you're representing yourself. You should not be wearing jeans before a judge. You should not have a hat. If you have a hat on, most likely the clerk of the court or the court service officer will come and tell you to take it off. But if they haven't, the judge definitely will. Especially if it's not part of religious garments. So, what are court practice directions? Well, these are essentially how the court is to operate normally. Now, there's different court practice directions in every jurisdiction, and you'll need to find out where they are. But search court practice directions in your province or your jurisdiction, and you will find them. They could be called something else. They could be called, courtroom directions. They may not be called practice directions, but here in Ontario and other provinces of Canada, they're called practice directions. So these are courtroom practice directions, and it's good to know them, but it's more important to know the rules. The rules of the court are really where the meat and potatoes are of your research and where it should be. You should be being able to quote all of, maybe not even quote, but have printed off every single rule that is applicable to your case. You should have it at your disposal. If you don't have, a book like this that's called Civil Practice Directions, or sometimes in some provinces they're called different things, but essentially they're a book of the rules. And those contain the practice directions, I believe, too. They contain cases of leading cases or references to other cases. But what's good to know is that good research can't be beat. If you have your research down, nobody can stop you. If you have precedents from the Supreme Court that outline different orders and why they should be made, and you know all the tests and there are tons of tests. When I say tests, there are, in the most common family court trial, I'd say you'll be looking at 50 to 100 different tests that need to be examined by the judge, that need to be implemented by the judge. And these tests could be what a single word means. What is the test for this particular word? The word could be anything, but there's probably a test to see if the definition applies in your circumstances. The test for, whether or not somebody is acting reasonable. There's a test for that. Guaranteed there's a test for that. There's a test for the best interests of the children. And this, if you're in family court, if you're in any province across Canada, and you're in family court and there is children involved, you need to know what this test is. This is a test that you must have memorized. Memorized. If you're in Alberta, take a look at Section 18 of the Family Law Act in Alberta. Or if you're in Saskatchewan, Section 4 of the Child and Family Services Act. All of these sections that I'm pointing out, I'm only going to point out one other section here in Ontario. All of these sections give you essentially the definition or the test that is necessary, the bare bones minimum of what need to be achieved for applying this test of the best interest of the child. So if custody or access is an issue in your case, you need to know what the best interest test is. Here in Ontario, Section 24 of the Children's Law Reform Act has what's called the merits of application for custody and access. And under subsection 2 of that section, it says the best interest of the test. It says the best interest of the child. And this is essentially, I'm gonna read that section right now, and it will give you an idea as to what you need to be looking for, as if you live in other provinces or in other jurisdictions. This is across North America. You'll find tests like these. So, subsection 24.2 of the Children's Law Reform Act here in Ontario says, the court shall consider all the child's needs and circumstances, including the love, affection, and emotional ties between child and each person entitled to or claiming custody of or access to the child, other members of the child's family who reside with the child, and persons involved in the child's care and upbringing. B, the child's views and preferences, if they can be reasonably ascertained. C, the length of time the child has lived in a stable home environment. D, the ability and willingness of each person applying for custody of the child to provide the child with guidance and education, the necessaries of life, and any special needs of the child. E, the plan proposed by each person applying for custody or access of the child for the child's care and upbringing. F, the permanence and stability of the family unit with which it is proposed that the child will live. G, the ability of each person applying for custody or access to act as a parent. And H, the relationship by blood or through an adoption order between the child and each person who is a party to the application. Still in Section 24, subparagraph 3, past conduct. A person's past conduct shall be considered only in accordance with subsection 4, or if the court is satisfied that the conduct is otherwise relevant to the person's ability to act as a parent. Subsection 4, violence and abuse. In assessing a person's ability to act as a parent, the court shall consider whether the person has at any time committed violence or abuse against A, his or her spouse, B, a parent of the child to whom the application relates, C, a member of the person's household, or D, any child. And subsection 5, for the purposes of subsection 4, anything done in self-defense or to protect another person shall not be considered violence or abuse. So, what does this all mean? This is a test. That's one of many tests you'll encounter. You'll need to know what these tests are. Research, research, research is what you need to be doing if you want to be successful in family court. In summary, if you want to be successful in family court, stay out of family court. And if you can't do that, be open and invest an awesome amount of energy and time into alternative dispute resolution methods. Mediation is very popular. Get into mediation. If the other side doesn't want to be there, that's unfortunate. You can't control that, and that's how it doesn't work. But both sides need to be there. And when both sides are there, that means they're open to resolving this out of court. And what happens when you're out of court? That means you don't have to go in court. And a judge won't make up an order that you'll have to follow. Know the evidence. What will be necessary to prove your case? Know what's admissible or what you can or can't use in court. And as I just said, research. Research, research, research. Very, very important things if you want to be successful in family court. I invite your comments and questions below. I will post that video with Justice Brownstone below. I recommend, if you're in Canada, even if you're not in Canada, this is a great read regardless of your jurisdiction. If you're in family court, read this book. A judge telling you how it is. A family court judge telling you how it is. So comment below, and thank you for watching. And check out our fundraiser coming up on May 22nd, our Combating Loneliness campaign. It is a dinner and dance and a raffle for single people. A really, really fun event that is meant for healthy and happy people. And where the common thread of everybody involved at the party will be that they are all single. So, come on out to that. Check out our other fundraising endeavors on irepmyself.com. Make sure you become a website member of irepmyself.com, as there is a website members section. And if you need coaching, you need support if you're in family court or in any other type of court, call us, email us. Email is on the website. Go check out the website for lots of great free information, and we hope to serve you sometime soon. Hopefully this has been some help. A big thank you to our fundraiser sponsor, David's Tea. We have a new one today. I didn't get their logo in time, but Canadian Tire. Appreciate the support that they've given us in our upcoming fundraiser. And thank you for watching.